alternatively, we will answer them at the end. So we'll try and get through as many of them as possible today. And if you have anything after the broadcast and you want to answer sort of questions particular to your organisation, then we can do that offline as well. Okay, so what are we actually going to look at today? We have an overview. So why do we have disciplinary processes? What is the process all about? We'll talk a little bit about the legal position, because obviously there have been some changes in legislation and best practice as well, and we'll talk about how that's actually working. One of the things I do want to talk about today is investigation and the importance of that in the disciplinary process. So we'll look at why we investigate and what it adds to the process as well. One of the things that is really important in dealing with disciplinary issues and dealing with the process is the manager's role, and actually what that looks like and some of the skill sets that you might need as a manager to deal with these issues. And then we'll talk a little bit about determining the outcome, because that can be quite difficult depending on the circumstances and the breadth of information that you have available, and looking at that. So that's actually what we're going to try and cover today. In some areas it may be a bit of a whistle-stop. It may be a bit of a whistle-stop process. So we are going to go through quite quickly. Okay, so why do we have a disciplinary process? They are actually quite important to our organisations because they do set our standards and expectations. Very often when an individual joins your organisation, they are coming from a different background, where standards and expectations in a different organisation actually cloud their judgment, if you like. And you want them to understand what you expect. And the sorts of things that you'd be thinking about giving them some idea of are things like timekeeping, conduct, and standards of behaviour that you expect from anybody working within your organisation. It's also important to outline the consequences. So if an individual is 10 or 15 minutes late every single day, and you're not happy about that because you don't have flexible working and you need them there at 9 o'clock, not at 9:10, then obviously they need to understand that if they continue to behave in that way, that there are going to be consequences, whether those are informal or formal, and actually that it could ultimately, if they don't change their behaviour, end up with them losing their job, which is obviously the ultimate consequence when we're talking about disciplinary processes. It's actually also an effective management tool if used appropriately, because it allows you to follow through a standard process. And it actually creates understanding, so you are reinforcing the message of what your standards and expectations are for your organisation. And it's also an opportunity to actually let staff know what you expect. You don't necessarily have to go all the way through to dismissal to actually reinforce the message, to tell them that actually turning up at 9:10 when they're due to start at 9 o'clock is unacceptable. What we hope is that it may be the informal action and you telling them that that's a problem is enough, but actually you may well go to just a first warning and deal with it in that way, and they understand that this is unacceptable. So it is a management tool. We talk about carrot and stick, and obviously disciplinary processes are very much seen as the carrot, but actually what they can also do is to use to improve conduct and performance, because people understand what your expectations are, and also that actually you won't put up with bad behaviour, lateness, or other issues that are affecting your ability to run your organisation in the way that you want to, usually to meet customer or client expectations. One of the things to think about here is if you don't set the standards, then actually employees may set their own, because they do bring with them their own understanding of what is acceptable. Previous employers may have said, well, actually coming in 5-10 minutes late is fine as long as that time is made up, and they have that flexibility to deal with the issues, and for that business that's fine. If you open your doors at 9 o'clock and you have clients stood on the doorstep because somebody hasn't actually opened up, then that's not acceptable, but that may not have been an issue previously. So disciplinary processes are really important, in actually your people management framework, and to support what you expect from employees when they join you and throughout the life, that they have with you as an organisation. Okay, one of the things that I do want to talk about is the legal framework, because this is actually quite important. The disciplinary process under the ACAS Code of Practice is actually put together in such a way that it outlines best practice across all organisations. It's what employment tribunals use as their standard when they're making decisions with regards to claims for unfair dismissal, and has the organisation operated in a reasonable way? Did you follow a good procedure? And this is what they tend to base that information on. The ACAS code is something that is pretty standard. We all understand about, first written warning, final written warning before we actually achieve dismissal. But one of the things they're actually talking about now is the basis of an informal process. And there is definitely a push towards dealing with things before you actually get into the informal process. And the structure of the ACAS code outlines that quite strongly. It is a structure that most of us understand, and actually not only employers but employees as well know what a normal average disciplinary process looks like. And if you stick with the code of practice and use that to inform the disciplinary policy and procedures that you operate within your business, and you follow them, so you obviously give managers training and you outline for them what your expectations in managing that process are, you won't go far wrong. When we actually veer from the code of practice, that's when issues start to arise, and when employees may actually have a claim under unfair dismissal legislation to an employment tribunal. That said, we all know that employees can also take claims when we as employers feel that perhaps they are vexatious and actually they're only doing it because they either want to get some money out of us or because they want to put their point of view across, and actually it's not a valid point as well. There are some rights around unfair dismissal, and there were some changes both last year and more recently in July of this year to the changes in legislation. From April 2012, the law has been extended in terms of continuous service for an employee to make a claim to a tribunal for unfair dismissal. And to claim unfair dismissal, they actually now have to have 2 years continuous service. Anybody who was employed before April 2012, it's still 1 year. That doesn't mean that you shouldn't follow a good process and actually stick with the ACAS code, because there are still risks associated with not following a good procedure. And obviously, if your disciplinary process is connected with your contract of employment, you could be looking at a breach of contract claim instead, and that brings with it other risks. But more importantly, if the employees that are working within your business see that you're not prepared to follow a good practice, and that you only, you get rid of people at 1 month before the 2 years, for example, that actually creates bad press for you as an employer, and actually could have a negative impact on people staying with you, delivery of service, and actually them connecting with you as an organisation. In terms of the more recent changes in legislation, there's been quite a lot of press around this, and it is linked with changes in the way employment tribunals are operating, because there were a lot of cases going through the courts, and it was felt that some of them shouldn't have actually reached that stage. Now, what it's saying is that if an employee takes a claim to an employment tribunal, they will actually have to make a payment now. Now, these have been set for unfair dismissal. In making the claim, the employee has to lodge £250 initially with the tribunal, and then if that claim actually goes to hearing, they will actually have to put up front £950. So in total, they are actually putting up £1,200 to take a claim through to the tribunal. If they win that claim, they will actually get that money back. Obviously, if the employer wins, they've lost it. The idea behind this is actually trying to discourage employees from making vexatious claims and for those claims that don't have merit. However, that said, there is currently a challenge going through the courts against the fact that employees have to pay to take claims to tribunal. And it has been said that should that claim be successful, then obviously anybody that has had to pay since the legislation changed on the 29th of July this year will get their fees reimbursed. So it's kind of still watch this space a little bit with regards to the changes in legislation. One of the other reasons to think about having a good process is actually the risk assessment for your business. And actually, if you lose in tribunal, it can be quite expensive for you if you haven't gone through a good procedure. The costs and awards that are made are basically made up of two parts. One is the basic award, and this is calculated based on the same legislation as outlined for calculating a redundancy award, and currently is a maximum of £5,500 for somebody who has got 20 years service, but that is absolute maximum. Now the compensation award is capped at £74,200. Now that sounds an awful lot of money, and those, if you look at the tabloids, are the sorts of headlines that we all see, where employees have got very large awards given to them. One of the things that, again, under the changes in legislation in July this year that came out was to actually cap expectations for employees. And an employee who is earning less than £74,200, it's now capped at equivalent of 12 months' salary. So if you have an employee who only earns £20,000, the maximum compensatory award that they could get now is £20,000. However, if an employee earns £100,000, it's still capped at £74,200. Now, what we are looking at here is not just salary costs. It is looking at things like bonuses, commission, any benefits, and obviously pension costs. So the tribunal will look at what their package total is in terms of a money figure, and they will utilise that. When they're assessing a compensation award, what they're thinking about is what is the loss of earnings for this individual in losing their jobs. And if they feel that they have lost their job unfairly, they will look at past and future losses. So if somebody has been unable to find a job, and they've been unemployed for 3-6 months, they will look at that. They will also look at how much longer are they likely to be unemployed for. Now, an employee is expected to mitigate that loss by making sure that they have looked at finding work, so they can't just sit at home on the sofa and watch daytime television and expect to get a payment through the courts. They are also, if they have found alternative employment, but the package that they're getting from that new employer is less, then there may be a sort of top-up compensation payment that may be awarded. Okay, so looking against that background, you can understand why, not only in terms of setting your standards and expectations, looking at the risk and the financial risk, particularly if you were to go to an employment tribunal, and the costs we've just talked about are only those that are awarded to the employee, doesn't take account of legal fees, the time and energy that it actually takes to put a case together, which, believe me, is quite considerable. It's also about establishing yourself as a good employer and setting the consequences for people that don't behave in the way that you want them to. So what is the process that a disciplinary action should go through? So if you want to take some disciplinary action against somebody, what are you going to do? And again, this is taken from the ACAS code, so it should be familiar to a lot of people. It is about establishing the facts, find out what's gone on, and really understand not only what the headline facts are, but the reasons behind why things have happened. You know, is there something else that is reinforcing the message and the behaviours that you're seeing? You need to tell the employee that there's a problem, and actually, you know, ask them why they're behaving in a certain way. You will have to hold a formal meeting to discuss the issue, and actually, again, in terms of holding the meeting, you do need to formally invite them to that meeting. And again, we would normally advise putting that in writing so that they understand exactly what that meeting is, when it's going to be, who's going to be present, so that there are no surprises. And if you have gone through the investigation process, and we'll talk about that a little bit more in a few minutes, they should have any documentary evidence that you've got to support your position, and so that they understand that you're coming from as the employer, so that they can actually respond during that meeting. You need to allow employees to be accompanied, and that is set out again in the Code of Practice as a trade union representative or a colleague. This is not mum, dad, you know, aunt, uncle, their lawyer. It really is very much specified as to who can be that companion. And there is a reason for that, because obviously it would be very difficult for an employer if the employee brought their lawyer to that meeting, and that actually isn't allowed at this point. However, in certain circumstances, it does say in the ACAS code that they are entitled to be accompanied at the formal meetings and not at informal meetings. So things like your investigatory meeting, which are outside of the formal process, they are not allowed to, or you do not have to allow them to be accompanied. That said, I would always look at the circumstances, particularly if you've got young employees, as to making sure that they understand what the process means and what the consequences could be. And it may be in that circumstance that actually you would allow them to have somebody present earlier in the process than at the formal meeting. You may also, in that circumstance, allow it to be somebody outside of a trade union representative or a colleague, and you may allow a parent to be present. So again, it's always looking to be fair and reasonable in the individual circumstances. So again, once you've been through your meeting, you've listened to the employee, you know, you've listened perhaps to any points that their companion wants to put before you as well, and you've taken all of that into account, then you need to decide upon the appropriate action. And this is where it gets quite interesting, because what it does say is that that appropriate action needs to be within the bounds of reasonableness. Now, what I might find reasonable, another employer may not. So again, you've got to think about it from the point of view of, would somebody else make this decision? Okay, we talked about somebody being sort of 10 or 15 minutes late for a week. If you haven't spoken to them about it and you get to this point and you've had no informal communication and you decide, I've had enough, you know, I'm going to sack them, is that within the bounds of reasonableness? I think it's unlikely. If you can demonstrate that you've talked to them, you've checked out the facts, you've been through the process and you have issued warnings, and then you sack them, yes, it may well be within the bounds of reasonableness, but to go straight to a dismissal, probably not. With any disciplinary process, there has to be the opportunity to appeal, and for the employee to talk to somebody else, ideally, about what process you've actually gone through and the decision that you've made. And again, it's just allowing them to have their say, to raise other points or to challenge the decision that you've made. I'm sure this structure of action is very familiar to employers, because again, it is very much linked to the standard and average structure that most of us put within our policies and procedures. One of the things we have on here now is an informal activity. Now, the informal activity is not part of your formal disciplinary process, but there is an expectation under the ACAS code and therefore under best practice to have spoken to people about small issues and problems, i.e. the lateness, for example, before you actually move to formal disciplinary action and going through a formal process. You will find that often by having a quick word or a conversation with somebody about behaviours that you as the employer don't like, they may change their actions without you having to go through a formal process. As we talked about earlier, an employee who comes in 10 or 15 minutes late has been used to making that time up at a later date because maybe it's for traffic, childcare issues that occasionally they encounter, and previous employers have found that to be okay. If you have a quiet word and say, really, we have to have the doors open at 9 o'clock, that's when our customers turn up and that's when you need to be here, that may be enough to change the behaviour and for them to understand what your standards and expectations are, instead of actually coming down on them like a ton of bricks and taking them through a formal process and giving them a warning. That's not to say that if you have had that quiet conversation about their behaviour and they do nothing about changing it, that you shouldn't then invoke your disciplinary procedure. Of course you should, and that's what it's there for. It is to reinforce messages, standards, expectations, behaviour and conduct that all employees have within your organisation. So then we would move through to a first warning. One of the things you'll notice here is we're not talking about verbal warnings anymore or written warnings. We talk about a first warning. I always found verbal warnings a bit of a strange misnomer because we tell somebody there was a problem, we'd call it a verbal warning, and then we'd write to them and confirm it. Automatically, you've gone from telling them off, if you like, to actually issuing them with a written warning. And part, again, of the ACAS code was to change that perception. Verbal warnings, if you like, are now part of the informal activity because by having the conversation with somebody about their behaviour and the way they're dealing with particular problems before you take formal action is, in effect, if you put it in inverted commas, a verbal warning. So a first warning is now your first part of your formal process. And then actually you can go to a final written warning and then dismissal or action short of dismissal. Action short of dismissal is an opportunity where perhaps you've got a good employee who really hasn't done anything wrong, but normally you would look at dismissing them for the behaviours that they've been demonstrating or the conduct that they've undertaken. And you can actually take action short of dismissal. Now, you maybe need to be careful here because if you've got nothing written down or nothing in your contract of employment to allow you to do this, then you may need to get their agreement before you actually take this action. The sorts of things that we're talking about are maybe a demotion. Somebody is in a supervisory position, so you demote them back into the team. A period of unpaid suspension, so they're actually out of the business for a week and you don't pay them for that week. Or an extended warning. Normally, when we're talking about final written warning, it's likely to be in the region of 6 months for a period. It's likely to stay on their file for a period of 6 or 12 months, depending on the structure of your policy, and you may extend that. Now, again, you do need to be careful here if you're going to extend the warning to show that it is still within the bounds of reasonableness in relation to the action. So if somebody, you want to extend it from 12 months to 2 years, for example, that may be reasonable, but you need to demonstrate that in your decision making and show that that is reasonable in the circumstances. We talked there about an unpaid suspension as something instead of dismissing somebody. One of the things you need to remember, though, is that that is a sanction. Where you are suspending somebody to be able to investigate and to go through the process, because by having them in the business it could damage that investigation, that is not part of your disciplinary process. It is not a sanction, and it's important to differentiate between the two. One of the things I've also put on here is gross misconduct dismissal, because although it is a dismissal, it is something that you will only use in very extreme circumstances where actually there is a fundamental breach in the contract and the behaviour of the employee or the conduct of the employee has led you to that decision. Sometimes here we talk about instant dismissals. That again is never a good place to be. If you are seriously considering dismissing somebody for gross misconduct, then I would say that actually what you need to do here is actually make use of suspension and go through the process. So you would still need to establish the facts, i.e. investigate, talk to the employee about the problem, hold a formal meeting, listen to what they've got to say, and then check that your decision is reasonable and falls within that bounds of reasonable, and that another employer in similar circumstances would see this as action that they would take. So we don't actually talk about instant dismissals with gross misconduct. If you do dismiss somebody for gross misconduct, then actually they're not entitled to their notice, and that's where this idea of instant dismissal comes. For any other dismissal, if you are dismissing somebody, they are entitled to their notice either as per their contract of employment or their statutory entitlements, whichever is more beneficial to the employee. In gross misconduct dismissals, that doesn't need to happen, and you are entitled not to pay them for that notice period. That said, they are still entitled to holidays, and they are still entitled to be paid for work that they have already done for you. Okay, so let's talk about the practicalities of investigation. It really is an incredibly useful tool if used well, because actually it gives you that ability to take a few minutes out and think about, what am I doing? Why am I doing this? So who is actually going to conduct the investigation? Wherever possible, this should not be the manager who will actually be dealing with any formal disciplinary process. Again, it's about being fair and reasonable, so that if you've investigated it, you're not the person making the decision, so in terms of a disciplinary process, because you haven't got preconceived ideas. Now, that is not always practical or possible within a small organisation. So if you have to be the investigating manager as well as the disciplining manager, then you need to be very clear in terms of the documentation that you pull together as your investigation, and to make sure that you have been fair and reasonable in the circumstances, and that you haven't prejudged any disciplinary action. So again, that hearing that you have where the employee is accompanied in that formal meeting, you are probably going to be going over again the conversations that you've had as part of your investigation and your fact find. But it is really important to show that you were fair and reasonable in these circumstances. So what are you trying to investigate? You are trying to establish the facts. You are going to talk to the employee. You are going to get them to tell you what's happened. You may ask them to put a statement together. There may be other people that you need to talk to as part of that process, or there may be other documentary evidence that you need to gather. So you may be looking at record keeping, you may be looking at history in terms of computers or records that you keep as a business. Why do we do this? Well, we want to establish what happened. Is it really a disciplinary problem, or is it something that actually can be addressed in a different way? We talked about, and I've used it as an example all the way through the conversation that we're having this lunchtime around lateness. Now, it may be that that lateness is only for a short-term period. I don't know. Mum's not able to take the kids to school and dad's having to do that. Now, I am stereotyping there, so I apologise up front. And it may just be that it is for a very short period of time, and that allowing that to happen for a week, 2 weeks, may resolve the problem without actually going through a formal disciplinary process. Now, if you hadn't investigated and talked to the employee about what was going on, you may not have found that out until such time as you sat in a disciplinary hearing. So that's why we investigate. The how it really does depend on the circumstances of what it is you are investigating. Somewhere in that, you are always going to have a conversation with the individual about what's happened, why it's happened, who else is involved, whether it's just them or whether any colleagues. But also, you may find that you need to go and dig deeper, and you may, as I said earlier, be looking at the records that you keep within your business. That may be computer records, it may be paper records. It depends on the circumstances. Once the investigation has, you've actually completed that as the manager, so you've understood who's involved, what's happened, why it happened, and you've got all your information gathered, then actually what you're going to do as the investigating manager is make recommendations. As I said earlier, ideally to a manager who is going to make the final decision as to whether disciplinary action is appropriate in these particular circumstances. And here you're making recommendations as to whether you think it should be a formal process that is now followed, i.e. you are going into your disciplinary process, whether there is an alternative way forward, whether you've actually got just a general conversation with the individual concerned, whether you allow a short period of lateness in this particular circumstance to continue and that you will review it in 2 weeks' time, whether you set objectives because somebody really didn't understand that what they were doing, perhaps they're new to your business, they came from a very different environment where certain behaviours were acceptable, or you're actually going to say that you think in this circumstance no action is recommended because having investigated it, actually it didn't happen as was perceived by the manager who particularly raised this in the first place. Okay. Managers take the brunt of dealing with disciplinary action and dealing with the sorts of problems that happen within businesses on a day-to-day basis. A lot of the skills needed to deal with these issues, you as the manager will deal with and have, and you use them on a day-to-day basis generally within your organisation. We expect managers to behave in a professional way. So again, you understand your processes, you make sure that you're not putting the business at risk. Because if you are the disciplining manager and if you don't follow the process that you have established within your organisation in a professional way, actually you are putting the business at risk of those costs that we talked about under the legal framework. Or even if you decide as an organisation to settle, that could still be several £1,000s. And I'm sure, as with most of us, we would rather spend that on something positive within the business rather than actually settling with an employee who is disgruntled, and it sends quite negative messages. You need to be able to diagnose the problem, so you need to be able to understand why something has happened, how it's come about, and actually distinguish whether it is a serious matter that does need to be dealt with through the disciplinary process or whether actually the problem could be addressed in another way, and to understand that. As with all people management issues, we need to be able to communicate. We need to make sure that the employee understands what needs to be corrected, why it's a problem for us as a business, and that's about not only talking to them or talking at them, as sometimes happens when we have a particular problem, but actually listening to their responses and actually taking that into account. When we're communicating, we have to remember that actually we have 2 ears and 1 mouth, and actually we should do more listening and less talking at times. But you do need to make sure that the employee understands that they need to change their behaviour. You're going to be making decisions, is disciplinary action appropriate? And that's analysing the problem, analysing the circumstances, and establishing what is appropriate so that you actually make sure the punishment fits the crime. You know, that employee who he's having to pick up the slack and drop the children off at school for 2 weeks, and you're sat there thinking, well, I'm going to sack him, is probably not appropriate in the circumstances, and we go back to the fact that that then could cost you quite a lot of money. It is also a manager's role to help the employee improve in terms of their behaviours, their conduct, so that they are actually going to achieve the standards and expectations that you have of them. And therefore, as a manager, you need to support them to do that. It could be a training issue. It could be about explaining what the expectations are, again, and reinforcing them within your business. But actually, you are there to help the employee achieve. Because if they're achieving the standards and expectations that you have of them within the organisation, then actually that allows them to move forward and to deliver the services, products that you need to as an employer. One of the things here, again, we come back to communication, and the communication is not just about communicating what needs to happen now, but actually if they fail to achieve the standards and expectations, and providing, of course, that your standards and expectations are reasonable, if they don't achieve that, what are the future consequences? What's going to happen to them? And ultimately, if you go through your disciplinary process, then actually that is going to be that they will lose their jobs. But that is something that you need to be talking about with them, and you actually need to be having these conversations quite early on. One of the things that managers do when they're busy is to accept behaviour as normal. It's not that much of a problem. Oh, it's a bit of a niggle, we can work around it. And you allow that to happen. It just reinforces the bad behaviour or the behaviours that are not acceptable to yourself, to colleagues, and actually then you start to get into a bigger problem. So one of the things that is really important for managers to do is actually to pick up on things that are quite small quite early on, and just have that quiet word with the individual around what the expectations actually are. And the more you do that, and the more you use your informal processes, actually the easier it is to manage people, to manage teams, and you will find that you're actually using your disciplinary process less, because actually you're picking up on things and dealing with them as they arise, and more quickly than if you leave it until it becomes quite a big issue. Maybe you've got a complaint from a colleague, a customer, and although actually, if I'd had that quiet word, we wouldn't be in this situation. And actually you're creating more work for yourself, because you've then potentially got to follow a formal process. And disciplinary processes are quite time-consuming, particularly if you actually go through to, all the way through the process, and you build in the appeal process as well. And that actually can take time from doing other things. Okay, we've talked a lot about the process and giving you an overview of the legal entitlements. One of the things that's quite important here is determining the outcome of a disciplinary process. Does it fit within the bounds of reasonableness? Would another employer make the same decision in the same set of circumstances? If you want to sack somebody for being late on one day, would another employer do that? I think it's unlikely. If the employee has been doing this for a period of time, you've told them about it, and they're still doing it, then maybe. But does it fall within that bounds of reasonableness? And if you end up in an employment tribunal, that's also what they will think about. Is this reasonable? You need to think about the seriousness of the issue. Lateness, again, one-off, maybe not so much of an issue, happening every day and gone on for a number of months, quite serious for businesses. Deciding that you don't like, as an employee, you don't like your boss, and you decide that hitting him, swearing at him, or not behaving in a very nice way does happen. Not very often, I'm pleased to say, but it does happen. Then that is very different. So you need to think about, where does this fit? Is this out of character? Have you got an employee who's been with you for 4 or 5 years, and this is completely out of character? They haven't done anything like this before. they've behaved in the way that you would expect them to, they've achieved standards that have been set out for them. So is it out of character? If it's out of character, then you may feel that in the circumstances, again, going back to the seriousness of the issue, that it's not appropriate to take disciplinary action on this occasion, or you may decide that it's a first warning rather than a final warning or dismissal. Remembering, of course, that actually once you go into the formal process, you can start at any level as determined by the seriousness of the issue, taking account the employee's record and whether this has happened before. So for an employee where perhaps they have got a really good record, they've been with you for 4 or 5 years, nothing has happened, and they decide to shout at their manager for some particular reason, you may decide, okay, that behaviour is unacceptable and it needs to be addressed through the formal process. But you might decide that actually I'm going to issue a first warning, whereas somebody who shouts and screams at their manager and they've been told about it before, both informally or formally, may decide that actually we're going to go straight to a final written warning on this occasion because it's showing a trend in behaviour. You need to think about the level of authority that you as the manager have, because again, is it appropriate for you to be taking this course of action? What does your policy say? And it is important to follow that policy, because again, what you don't want to do is end up in an employment tribunal and find that actually you didn't have the authority to dismiss, didn't have the authority to issue a final written warning because it should have been the next level of manager, because that may, and I say may, impact on whether the employee wins or whether actually you do, as if you end up in a tribunal situation or even an appeal, because again you haven't followed your process. I mean, are you being fair and equitable? Is this the sort, in setting your standards and expectations of behaviour, do you then treat everybody the same? So if you've got somebody who you allow to be 10 or 15 minutes late, you may not know the reason, but if others don't understand that that is acceptable in a particular set of circumstances and they behave in the same way and you actually formally discipline them, they may say, well, hang on a minute, that's not fair. So again, you need to demonstrate that what you're doing is consistent across the board. And finally, is your decision constructive? Disciplinary process is not that big stick. It is also about improving standards, improving behaviour, and actually getting people to understand what you expect of them as employees within your organisation. Is the decision going to help you to do that, or is it just going to send a very negative message? You need to think about it. I'm not saying you shouldn't issue warnings, because that's what the disciplinary process is there to do and to help you enforce the message of what's expected in your business. But is it constructive? And if you do decide to issue a warning, alongside that, do you put in place an improvement plan? Do you put in place objectives that will help the individual achieve your standards and expectations? Okay, well, thank you very much for listening. I hope that you've found that useful. As we've gone through, there haven't actually been any questions today, but as I said at the beginning, if there is anything that you would like to pick up with me offline, then I'm very happy to talk to you about that and answer particular questions around disciplinary processes and disciplinary procedures and how to avoid employment tribunals and the costs associated with that. So thank you very much.